Everyone, and before we call this meeting to order, we will hear instruction on how the public may access Spanish interpretation.
Good afternoon. We're offering live interpretation in Spanish during this meeting. If you wish to hear Spanish interpretation, please click the interpretation button at the bottom right corner of your Zoom screen. You will see a globe icon and select your language of preference. If you're joining via the Zoom smartphone app, select your language by clicking More or the three dots in the bottom right corner of your screen. Select language interpretation and choose Spanish and click Done.
Okay.
If you wish to hear only the interpreters and not the original speakers, be sure to click Mute Original Audio. Buenas tardes, estamos ofreciendo interpretación en vivo en español durante esta reunión. Si desea escuchar la interpretación en español, haga clic en el botón Interpretation, que significa interpretación, en la parte inferior derecha de la pantalla de Zoom, y asimismo verá un icono de globo terráqueo para poder unirse en su idioma de español. Si se está uniendo a través de la aplicación Zoom para smartphone o teléfono inteligente, seleccione su idioma haciendo clic en More, que significa más, o en los tres puntos en la esquina inferior derecha de la pantalla. Seleccione Language Interpretation, interpretación del idioma. Después elija Spanish y haga clic en Done, significa listo. Si desea escuchar solo a los intérpretes y no a los oradores originales, asegúrese de hacer clic en Mute Original Audio, silenciar audio original. Thank you, and back to the commission.
Thank you very much. With that, we will go ahead and call this meeting to order. Everyone rise for the Pledge of Allegiance. All right, thank you. We'll move right on to roll call.
Yes, I will be taking roll call. Chair Viorchek.
Here.
Vice Chair Lexinger.
Here.
Commissioner Feiger.
Here.
Commissioner Imhoff.
Here.
Commissioner Williams.
Here.
All present, Chair.
All righty. So we will start this meeting off with our public communications, and this is the public's opportunity to speak on any subject which is not on today's agenda. Comments would be limited to 3 minutes. Do we have anybody who would like to speak? Seeing none, let's open it up to Zoom.
We have no attendees over Zoom at the moment.
All righty, that makes it easy. We will move on to our consent agenda. In this case, it is the Planning Commission meeting minutes, and once again, we will start with the public's opportunity to speak on the subject. Do we have anyone in the audience? Seeing none, and I'm assuming...
No attendees over Zoom.
All right, bringing it back to the Planning Commission, do we have a motion or any discussion?
I'll move to approve the consent agenda.
I'll second.
I'm sorry, who was that second? Thank you. All right, that motion carries.
All right, thank you. And with that, we will move on to kind of the meat of our meeting. So in this case, we will be considering the appeal of Mr. Grove regarding the denial of a VHR permit application at 759 Lakeview Avenue. And we confirm that the notice of the appeal hearing was published in the Tribune on August 8th, 2025, and a copy has been provided to the appellant. And I just kind of want to go over the rules of this a little bit because this is a little different than a standard Planning Commission item. So in this case, we are going to start by hearing evidence and testimony from the staff to provide background information on the matter. And as we kind of finish up each section, I'll go over the regulations and the rules sort of for the next section and go over who will be speaking and what they will be speaking about. So let's go ahead and start with staff. Thank you.
Good afternoon, Chair and Planning Commissioners. For the record, John Hedgecock, City Planning Manager. Just want to give you a little brief background. The agenda item before you is today is an appeal of VHR vacation home rental application rejection submitted by Mr. Grove, doing business as Grove Oxygen Services and Supply. On June 23rd, 2025, the city received an application for vacation home rental permit for a project located, for a property located at 759 Lakeview Avenue. Mr. Grove previously held a vacation home rental permit due to previous vacation home rental was closed on September 8th, 2021 pursuant to Measure T. The Community Service Division received Mr. Grove's application on July 10th, 2025. The Community Services Division deemed that the property was ineligible for vacation home rental permit due to having 3 or more upheld citations pursuant to City Code Section 3.50.410.b. Per City Code Section 3.50.430, an applicant may appeal the city's manager's decision to issue, deny, or revoke or suspend a vacation home rental permit to the Planning Commission. Mr. Grove, the appellant, filed an appeal with the city clerk on July 22, 2025, within a timely manner. Mr. Grove stated in his appeal that at least 2 of these 3 citations issued had extenuating circumstances due to miscommunication between Mr. Grove and city staff. City staff will present factual evidence in a record that indicates the property was advertised on at least 3 occasions in violation of the vacation home rental ordinance. Thus, the city's manager's decision to reject the application is appropriate and consistent with intent and spirit of the vacation home rental ordinance. And that concludes my opening statements on this appeal. Thank you.
Thank you, Mr. Hitchcock. With that, we will go ahead and move on to our next item, which is an opening statement or remarks by the appellant and/or their attorney, and evidence or testimony from the appellant. This will be followed by the commission's option to ask questions of the appellant. Others, including staff who wish to ask questions, may also do so. All right, please come on up, Mr. Grove.
Thank you, Chair, Commission members. Mr. Hitchcock, thank you for sending me the packet this morning that I could print out and review prior to driving up here. My name is Joe Grove. The property I live in Placerville. The property at 759 Lakeview Avenue has been in our family since the early 1970s as a family vacation home, primarily used for family members until 2015. That is when I relocated back to Placerville. My father had recently passed away. He's the one that acquired the property. And my mother, who was approaching 90, and was in need of some additional income, asked if we could start to short-term rent it while still providing time for family members to utilize the property. So back in 2015, I actually worked with Maureen Stolman on this. She retired, and Sonia Wheeler took her spot, as the package you have outlines. But anyway, I went through the process of getting a VHR permit and successfully started listing and short-term renting the property on Airbnb with 0 citations, 0 complaints of neighbors in the 6 years between when I started renting it and when Measure T went into place. At that point in time, I used Airbnb's option to freeze the listing for a year, which I believe my permit renewal was in August each year. So in early September of 2021, I froze it for a year. I remembered, I froze it again in 2022, and I forgot to freeze it in 2023. And shortly thereafter received a valid citation because it was actively listed on Airbnb in that month of September. Received a citation to that effect. I think that's in your packet as Exhibit 1. I reached out to Maureen, and she explained to me that there would be a written hearing in December the 14th of that year, 2023, and that I would receive notice of the decision within 1 to 2 weeks. So I had frozen the listing until the end of December 2023, expecting to have a decision by the end of the year. Nothing came. By the way, the business, Grove Oxygen Service, my mother, who this is for, she used to live in Camino. During all this time, she lived in Camino, and we got her mail from the post office box there. So I would go up to her home, usually once or twice a month, typically at least weekly, sometimes more than that. It all depended on how many rent checks we had for our commercial tenants, bills to be paid, etc. So, having not received any notice, I unfroze the listing January 1st, 2024, and started advertising it again on Airbnb. I found out in mid-January when I went up there again that I had received notice that the appeal was overturned, and there was also a citation, and then in the next 10 days there was actually a total of 4 citations. Your packet only shows 2, the one on the 17th and the one on the 27th. I froze the listing permanently this time. I didn't want to get into the same issue that caused me these problems. So it went unlisted right away after I got that last citation, and it remains unlisted today. The citations came. I reached out again. Sonia, by this point, had taken over, and I asked her what my options were. These are quite expensive citations for my mother and I to pay as part of our business, so she helped me both with the appeal process as well as filling out a hardship waiver. This time, and I said, can we have, at the very least, a phone hearing instead of a written one so that I can participate in that? And she said yes. So I believe it was in March of 2024 that we had a phone hearing, and the hearing officer listened to my explanation, which is in your packet, and they actually dismissed 2 of the 4 citations, which is why it's listed as 3 citations. The one in September, mid-January, 27 January. And so I went on. I didn't appeal it any further. I figured that was the best I was going to get, considering everything, and continued to keep the listing or the home unlisted on Airbnb, which was the only platform I used. And obviously, I was quite interested in the proceedings towards Measure T going away, which it did. And so the first day, which is June 23, that we could apply for a new permit, I did so. And then, as Mr. Hitchcock explained, it was overturned due to these 3 citations, I believe, in a period of 24 months, 2 years. So I talked to Ms. Blankenship about options to appeal, and she gave me the form and explained how to do it, which is what I did and why I'm talking to you today. And my quote-unquote extenuating circumstances are the fact that I did not go and do not go to the post office box every day. The time I went to post office box one time to the next, the decision and the citations had all shown up at once. And that's why I appealed it at that time, and that's why I'm appealing it right now. Those are reasons. Should I have gone up to the post office every day? Maybe, but there's not enough work to do every day. And sometimes I just go up to visit my mom and don't even go to the post office. That's all I have.
Thank you, Mr. Grove. Did you have anybody else who's going to be speaking in regards to, thank you. In that case, we're going to go ahead and allow the commission and staff to ask any questions, and we'll just go down the line. So, Mr. Williams, did you have any questions?
So then are we going to be able to ask commissioners questions of staff and so forth at
Yes,
this point?
there's a whole process. Currently, we're at the portion where we will just be asking the appellant
Okay,
any
that's
clarifying
fine.
questions to their explanation.
All right, so why did you only, after the first citation, why did you only do it till the end of the year? I mean, because obviously after the first citation, you already knew that you couldn't rent it out for less than 30 days. Why didn't you just put it on a 30-day rental period the Airbnb allows you to do? Why did you put it on so that, for nightly instead of putting it on to the 30-day after that first citation?
After the first citation, I filed my first appeal. I delisted it then, and I filed my first appeal, and in your packet is an email exchange between Maureen and myself, where she told me that the written hearing would be on the 14th of December, and that I would get an answer within 1 to 2 weeks. So that's why I froze it until the end of the year.
But you still would not have been able to rent it out on a nightly basis after the appeal.
I appealed to be able to rent it.
Oh, you never would have been allowed to do that.
I'm aware,
Yeah.
but I wasn't then.
Okay.
Do you have any questions? All right. For me, it's kind of a follow-up to Mr. Williams. So, were you aware of Measure T? I mean, there, obviously, like, you kind of knew when it was coming into effect, it had a major impact on your business. So it's kind of surprising to me that, yeah, you got this citation and then you froze the listing for a short period of time, knowing that Measure T bans short-term vacation rentals in general. So could you clarify why you did not just freeze it forever, essentially, rather than just doing it year by year?
Because I'm formerly a realtor, and I was involved with the Realtor Association up here to a small degree, and I knew that it was going to be litigated. So when Measure T went into place, I froze it for 1 year after my permit was no longer usable. And then I froze it again. Once that one came up, I froze it again in 2022, but did not do so in 2023. And that's when the first citation arrived.
And then the other clarifying question I have is, so you received 2 citations really close together in January of 2024, right?
Right.
And so can you explain how that happened? Because if you had, is that just because of the missing mail? Because if you had,
Yes.
I assume if you had received the citation January 17th, you would
Had I
have.
received it then, I would have frozen it then.
I see.
I didn't get it until I had the one from the 27th.
I see. Okay, that's the only questions I had. Julia?
So, Mr. Grove, you've indicated that you never had any problems in the past. Is that correct? When you had your last approval for permit?
Yes.
When you applied in 2015?
When I started, it was late 2015, and then 6 years roughly that I used Airbnb and rented it. I was a super host, which is close to 5-star rating, no complaints.
You've paid all your fines too, right?
I paid all my transient occupancy taxes, the ones that come on the green form every quarter, on time. And sorry. I'm
Yeah,
nervous
you know,
here.
I don't take a position on short-term rentals. However, I do take a very strong position on individual rights and property owner rights. And with that being said, that apparently you had violated, the ordinance on short-term rentals. These violations were a result of Measure T, which has now been rightfully overturned by the courts and is no longer the law of the land. You've paid your dues to society, and I feel as if there might be a little compassion in this particular case because of the fact that Measure T is no longer the law of the
Mr.
land.
Imhoff, I'm going to have to ask you to pause. This is specifically a period for asking the appellant questions.
That
Any
is-
statements will be for
Okay,
later.
that's
Thank
fine.
you.
Thank you.
I'm confused on who is the owner of the property?
It's actually held under the name of our business, Grove Oxygen Service and Supply. I'm the president, my mother's the secretary, we're a S corporation.
I have one last question for you. I know this is an emotional thing, so take your time. I was curious, have you, since Measure T came into effect, and I understand you were probably very much involved in everything, the appeals and sort of the legislation is going on, did you at any time consider doing a long-term rental while this was being resolved?
No, because of the fact that we used it as a family vacation home. And that's kind of the same reason I was adamantly opposed to Measure N, is having it rented long-term violates what us as a family wanted this home to be, something that our family can enjoy. And we're a blended family between my when I say my mom, she's technically my stepmom, but between my dad and her, they have 8 grandchildren and probably 16 great-grandchildren that we hope that this home will eventually go to someday. And anyway, that's the reason that I didn't even think about anything, even 30 days, It's usually occupied by someone from the family every month, but not every single day.
I appreciate your kind of explanation, clarification of the situation from your perspective. Since staff is also able to ask questions, is anyone on staff wanting to ask anything?
Thank you, Chair. Thank you, Mr. Grove, for being here. I just only really have one question. After receiving the first citation, you are aware that operating short-term rental or even advertising short-term rental post Measure T is legal, correct?
Post Measure T?
Yeah. So after December 31st, 2021, you were aware that it was illegal to short-term rental a property.
Yes.
Thank you.
Thank you, sir. We're going to move on to our next portion. You may go ahead and sit down. So at this point, we will hear any evidence or testimony from staff members concerning any issues that have been raised surrounding this matter. This will be followed by comments from the applicant. So Mr. Grove, once Mr. Hitchcock is done, you are welcome to come up. And then once that period is over, this will come back to the Planning Commission. And we and the appellant can ask questions of Mr. Hitchcock. So just to clarify, Mr. Hitchcock will give a statement. You are able to come up, Mr. Grove, and give a statement as well. And then both you and us as a commission can ask questions of Mr. Hitchcock. All right, thank you.
Thank you, Chair. For the record, again, Sean Hitchcock, City Planning Manager. Now I'd like to present the evidence to support the rejection of the vacation home rental application. The city alleges that on at least 3 occasions, the property was advertised online and city staff were able to book a stay at the property for less than 30 days. I did provide you with exhibits, print out copies of exhibit. In Exhibit 1 shows a screenshot taken by the Community Services Division on September 21st, 2023, indicating the ability to book the property from October 3rd to October 5th in violation of vacation home rental ordinance. The property was issued a citation on September 25th. Mr. Grove did appeal the citation, which was granted a hearing on December 14th, 2023. On January 12th, 2024, the hearing officer upheld the citation, which is on page 3 of the packet, of the exhibit packet. Exhibit 2 shows that another screenshot taken on January 17, 2024, indicating the property could be booked between March 8th and the 15th in violation of the vacation home rental ordinance. The property was cited January 17th. That citation was also appealed by Mr. Grove, and the hearing was granted on March 28, 2024. On April 23rd, the hearings officer upheld the citation, which is shown on page 7 of your exhibit. Exhibit 3 shows a screenshot taken by the Community Services Division on January 26, 2024, indicating that the property could still be booked between February 6th and February 8th in violation of the Vacation Home Rental Ordinance. Mr. Grove was cited on January 27, 2024. He was granted an appeal. The hearing occurred on March 28, 2024. And on April 23, 2024, the hearings officer upheld the citation, which is shown on page 11 of your exhibit. The factual evidence in the record suggests, the factual evidence in the record supports the conclusion that Mr. Grove received 3 upheld citations in a 24-month period for violating section 3.5.380 of the Vacation Home Rental Ordinance, which prohibits renting, advertising, or listing a dwelling unit for short-term rental purposes without a valid permit. During this time, the only valid permits that were permissible outside of Tourist Core was for either hosted rental permit or qualified vacation home rental permit, and neither were acquired for this property. Although Mr. Grove stated there are extenuating circumstances and related to at least 2 of the citations, Mr. Grove was aware that operating without a permit was a violation of the city ordinance. Thus, the city's manager rejection of Mr. Grove's application for a new vacation home rental permit is consistent with the intent of the law. City staff is recommending, based on this evidence in the record, that the Planning Commission, pursuant to section 3.50.410B, deny the appeal, and that concludes my presentation. Thank you.
Thank you, Mr. Hitchcock. So, Mr. Grove, if you have anything else you would like to add, it's not a rebuttal, it's just any additional comments if you would like to come back up and say anything.
I'm not going to repeat the reason those extra citations came in, but I do want to point out that there were actually two more between the 17th and the 27th, one on the 24th and the 26th, that when I had the March 24th phone hearing, I don't know if it was because the hearing officer felt they were too close to each other, or if he, I think it was a woman, took into account the fact that we had done a hardship waiver. But 2 of the 4 that I had gotten in that 10-day period were turned down or overturned, which is why right now the public record only shows the 3, September, forget the date, January 17th, January 26th. That's all.
Thank you. And did you have any questions for staff?
I'm anxious to hear what Mr. Imhoff has to say.
We'll get to that. In that case, we'll bring it back to the commission, and now it's our opportunity to ask Mr. Hitchcock any questions. Thank you.
I have a question. Mr. Hitchcock, in the new permit application and ordinance for vacation rentals, is there any kind of language about, I know there's something in there about if you've had a certain amount of citations, you can't reapply. Is there any kind of time threshold for that? Like, is this a forever thing? Does he not ever get to vacation rent again? Or is it like a 1 year, then he can reapply a year from now, or any kind of timeline on that?
That's a good question. I'm not sure, but we can look it up real quick. Dan, do you know? Mr. Barzell?
I'm not aware of any timeline that would
Yeah.
be limited.
The old ordinance had a timeline that you couldn't apply. I think it was a 2-year time period, but I don't know, I'm not sure if that made it over into the new ordinance, but we
Okay.
can
I
look
feel
it
like
up.
that could be important in our decision making, just because there's a big difference between that, him never being able to vacation rent again versus, some hope in the future.
Commissioner, we could, if you want to pause the hearing for a moment, we could confirm that for you.
We would love to do that. Let's go ahead and take, do you think 5 minutes is enough or 10?
Let's, 5-minute break would be.
5-minute break, and we'll return. Thank you. To settle back in, and we'll bring the meeting back to order. Mr. Grove, I noticed you had a question for staff, and I just want to double check that he can still ask questions.
Yes, he can. But I was going to respond to the commissioner's question. So we did confirm that it is a permanent prohibition for this owner at this property under the city code.
Would be a permanent ban. So they have just verified that. So Mr. Grove, you had a question for staff? Come on up.
I was under the understanding it was a 2-year exemption from being able to reapply.
That's actually incorrect. The statement I just gave is the rule.
I don't
Mr.
really have
Hitchcock?
any-
Oh, I'm sorry.
Oh, hold on one second. So right now, I know it's going to be kind of a little jiggle because this seems like it's something you are unaware of. This period is specifically for questions, not statements. You will have the opportunity to speak again. Do you have any additional questions regarding what staff has said thus far?
No.
All right, thank you, sir. So now it's back to the Planning Commission specifically for questions to staff.
To Mr. Hitchcock, is it possible to give him a conditional use permit with a probationary period?
No, there isn't. It's not, use permits are usually tied to land use decisions and projects.
Do we have any other questions for staff? Mr. Williams, go for it.
Do you have any proof or anything showing that he actually rented any of them out during these timeframes?
Yes, Ms. Wheeler, do we have any proof that he was actually renting?
There was some documented stays and reviews in the advertisement.
Would that,
didn't quite understand that. Would you hear?
Would it be possible for Ms. Wheeler to come up to the microphone?
Hi, yeah, there was documented stays and reviews. Documented stays and, and reviews from him renting.
What dates were those for?
I'd have to, that's not something that I did, that's not something that I provided. I just provided the citations, the upheld citations.
I would have thought that would have been pertinent to know.
If there's any information the commissioners need, please, staff, feel free to take the time you need to review the file to provide that, if it's available in the record.
It is, you'd have to give me some time. This was basically just on the citations that were upheld.
yeah, I would definitely agree. I think the dates will be very pertinent. I would actually say if you could limit in terms of your research, since we are kind of trying to keep this limited, specifically for that January period from the 17th through the 26th. I think, Mr. Williams, you would agree. Yeah, if you could check those specific ones to see if there was a stay during that time, I think that would really help us.
And nothing from September, even though those were upheld citations?
I personally don't, I'm not so interested in hearing about those. I don't know, Mr. Williams, what do you think?
Well, the September, there was no citation issued on the, for those. The only citation you have is for the 25th. And I am kind of wondering what, the citation was issued on the 17th. How long, and it seemed like you guys were immediately going after more citations after. Do you make a phone call or email or anything else to let them know, hey, take this down? Or because in a 10-day period, it sounds like you issued 4 citations without giving any time to correct any of the issues.
Correct, because the city code actually states that once a citation is issued, which the citation from September 25th was issued and it was upheld, so the property owner should have understood that he would be in violation, if that makes sense, after a few months. No, we do not email and say, hey, take it down. We've already issued citations. We've already advised the property owner. There's nothing that states that we have to reach out and say, hey, you've been cited not to do this anymore, if that makes sense.
Okay, so, yeah, I can understand why those other two were dropped. I mean, the mailing time from the 17th to the 10th, I mean, did it go out on the 17th?
They usually do, yeah.
But we don't
And
know
the city
that.
code only states that we have to send mail certified. There's nothing that states that we need to email and advise somebody to take that
Okay,
down.
so it was certified. Do we have the day of the certification of when
I
it went
don't.
out?
Kind of in that same vein, so in theory, could you have, like, for instance, issued the citation on the 17th, another on the 18th, 19th? Like, could it be?
Yeah, it can be each and
it
every
can be
day that the
daily?
violation is still
I see. So there's
correct.
no any type of grace period in
No,
order to
so
correct
if you're
the
issued a
violation?
citation and you receive the citation and you acknowledge the citation, then you're already aware that it's in violation and it's not to be done anymore. So the city code actually allows us to issue a citation for each and every day a violation still occurs. And that's clear on the city code.
And Chair, I'd like to point out too that, the city alleges that property was being advertised. Whether the property was actually actively being rented out is really not the issue here. The issue is Mr. Grove was cited for advertising illegally.
Thank you for that
Yeah,
clarification.
and I want to note that there was 3 citations previously issued from before September 25th. The issue was that he was advertising 763 Lakeview, so he was actually advertising his neighbor's home, which is in the citations, with the picture of him advertising his neighbor's home. So what happened was we issued citations to his neighbor because it was being advertised at 763 Lakeview. So 763 Lakeview was issued 3 separate citations, one on August 21st, one on September 7th, and September 21st. After September 21st is when the property owner of 763 Lakeview actually got a hold of our department and said, hey, we're being issued citations, we're not renting. I think it's 759 Lakeview. So then that was when we issued the first citation on September 25th. So there was actually more citations prior to September 25th, but unfortunately he was advertising 763 Lakeview, and those citations, you guys should have those citations.
That was 2023, right?
Correct. So in August of 2023, the South Lake Tahoe Police Department came across advertisements for a short-term rental at 763 Lakeview Avenue. 3 separate citations were issued on August 21st, September 7th, and September 21st. On September 25th, the property owner of 763 Lakeview Avenue contacted the department and advised the property was not being rented and believed the property being rented was 759 Lakeview. Please note, as you can see, the advertisements actually had a picture of 763 listed on the advertisement, which is why our system picked it up as so. A new administrative citation was created and issued to 759 Lakeview Avenue on September 25th. On October 8th, the appellant, Mr. Grove, contacted the department after receiving the citation and stated the community service officer was unconstitutional in issuing the property a citation, but ultimately took the advertisement down. On October 23rd, 2023, Mr. Grove read a letter stating that the administrative citation posed a financial hardship, that the rental income from short-term rentals compromised 65% of his family's monthly income, and that preventing him from renting 759 Lakeview Avenue was unconstitutional. He requested the citation be dismissed and for no further citations to be issued, and that is actually in his letter that you guys should have, and I can read that letter again. On January 17, 2024, an advertisement was found with the ability to book short-term for 759 Lakeview Avenue. The department had the ability to book from March 8th through March 15th, and an administrative citation was issued. On January 26, 2024.
A point of order.
This is, it's my understanding that this is in response to one of our questions.
Yeah, but our question was, that during that week timeframe,
I see. Yeah, so,
these
yeah,
are
so
all-
we've kind of gone backwards to evidence from a
Yes.
staff member. So I think, I don't know, Mr. Barzell, can we continue to listen to this, or are we going to go? Have we gotten a little too far?
This was also all in
Yeah.
our,
If it's helpful to the commissioners, you can ask her to continue. If you think you have enough, you can tell her to stick to the question that was previously asked.
I personally think I've heard enough. Anybody else?
I'd say it's been very helpful, but I've heard enough. I get it. Yep. Yeah. Thank you.
All right, thank you. So, Mr. Williams, do we still want to hear about the dates? Because as Mr. Hitchcock pointed out, that is not what the citation is about. It's more about the listing itself. So for myself, I don't need the additional information.
I'm fine.
Thank you.
Okay, thank you.
Do we have any further questions for staff at this time?
I had one question.
Go for it.
Sorry. Regardless of the outcome today, this property could still be rented for 30 days or more. Is that correct?
Yeah, that is correct. You can rent 30 days or more. That does not require a permit.
Great. Thank you.
And Mr. Grove, do you have any further questions for staff?
No, but I have a clarification.
That's next.
On the addressing.
That will literally be the next thing. So we will go ahead and move on to our item 4. And at this time, it's possible for the appellant, so Mr. Grove, to come back up and give us additional evidence or testimony that is in rebuttal to or in clarification of any of the evidence or testimony that has been presented so far, as well as any closing statements or remarks that you wish to make. So come on up and we will go ahead and listen to you.
Okay, thank you. First of all, Ms. Wheeler mentioned that there were citations that went to 763 Lakeview Avenue. Our home is one of 4 homes in a development on Lakeview Avenue. And originally, it was 763, unit number 1. The one right next to us was 763, unit number 2. They are literally share a wall, which is why they were zoned that way. And then there was a walkway between building 1 and building 2, and then you had 765 unit 1 and 765 unit 2 next to each other. After I started renting on Airbnb, the city of South Lake Tahoe changed our addresses so that now we went from 763-1 to 759. The next one, 761, the one that got the citation, 763, and the last unit, 765. So that's a point of clarification. I guess I want to, in a rebuttal, it's very disappointing to hear that if this is denied, I won't ever be able to short-term rent again. It is something that we were able to do without issue. And the reason Measure T went into place in the first place was because people that were renting were abusing the privilege and disrupting the neighborhoods that they were in. Too many people in each home, loud parties, trash, excess parking, etc. I just want to reiterate that in the 6 years that we legally rented, we had none of those things, 0. And we were able to generate some income that helped my mother and would still do so if I'm able to do it again. The idea of being able to rent for 30 days or longer is really not an option for us if we want to keep our home as a family vacation home. All I can do is, from the bottom of my heart, is stress that. I don't have anything else.
Thank you, sir. We will now take public comment from anyone that is here in the audience. Come on up, sir. And please state your name for the record, if you may.
I have a history as well. My application was denied due to violations, so-called violations. In 2017, I bought my place in the Keys to use with my family. The Keys are very expensive. Their maintenance was very deferred, and I had sewage backups. Then COVID hit. I bought the place with a rental permit, was paying my taxes, doing everything fine. And then came Measure T, and they never gave me my permit back. And this is how I live. This is my business. And I believe in property rights, and I don't believe in surveillance, and I don't believe in harassment. And Measure T, my application was denied, and I'm asking the city to also remove all the fines and grant me back my permit so you guys can generate taxes. And I'm not giving up my property rights, and I don't think he should give up his property rights. And Measure T was unconstitutional, and I am here before you guys to say, where do I go? Do I go to a lawyer? Do I gather up another crowd? Because, I mean, you guys all saw Measure T is gone. And, you know, I had multiple notices on my door harassing my people that were staying, my family. I went down to the police station. I filed a complaint of harassment, and I told the chief of police, next time I'll file a restraining order against the officers.
I appreciate your comment, and obviously it is public comment, but this is specifically in relation to the case before us.
Yes.
So
I'm with this gentleman here, and I don't think it's right that you guys still operate in the mentality of Measure T. It's gone. And anything before, anything that was taken out after, there's no legal standing. It shouldn't have been there. All those fines he got, they shouldn't have been there. The guy bought his place in when? 1971. That's a slap in the face. And during COVID, we got all slapped in the face, and people were grabbing power. And that's exactly what South Lake Tahoe did. A small little group of people, I didn't get to vote on it. So I sent the city monopoly money.
we're getting off subject again. I do
And you will
appreciate
continue-
where you are coming
and-
from.
And I want this resolved.
All right. Thank you.
Thank you.
Do you have any further comments specific to this case?
I know there's a hearing September 9th, and I'll come back, but I'd like to support his plea. There's no way that you guys can take somebody's property right away and say you can never rent again.
Okay, thank you,
Thank
sir.
you.
Appreciate your comment. Do we have any additional public comment at this time? Seeing none, do we have anyone on Zoom?
Yeah, we'll go ahead and open up our Zoom platform for anyone who would like to provide public comment on agenda item number 2. There are no hands raised, Chair.
All right, thank you. With that, we'll close public comment and we'll open it up to Mr. Barzell for a statement.
All right, so the commission will now be deliberating on the evidence and testimony presented. I want to admonish the commissioners that you have a duty to resolve any questions of fact that are pertinent to this matter and apply the applicable law to the facts. If you have policy disagreements with the law at issue here, that is something to raise with City Council. It would not be pertinent to the appeal at hand.
Thank you for that clarification. So now we are on to basically our deliberation period. So as Mr. Barzell mentioned, we are to deliberate on the evidence and testimony presented and vote on whether to grant the relief or action sought, provided they have all the necessary information. If issues are raised during the hearing that cannot be immediately responded to by staff, the hearing should be continued to have such information available for the appeal process. So I think we will go ahead and to try and keep it orderly, we'll go ahead and sort of start from Mr. Williams and come down the line with sort of our comments. But if you do have like a direct response to whatever the other commissioner is saying, just jump in.
Well, I'm kind of looking at this as a thing that the court found that Measure T was unconstitutional. And so if that was the case, then the advertising of a vacation rental probably was not illegal because Measure T was unconstitutional, found unconstitutional. So it pretty much invalidated Measure T by the courts did. So and until it's been that has been overturned on appeal, at this point, Measure T has been invalidated.
I think it's an important point of clarification, and I'd just like to note that, you know, this is the first one we've seen. We're going to see a lot of these potentially. So for me, this is really important that we need to be consistent. We need to be consistent with the city and need to be consistent with the city council. And that's our mandate. And thank you for explaining exactly what we're supposed to do. And so point of clarification is when the gentleman advertised and rented his unit, he knew it was illegal, and it was illegal at the time. So regardless of what, I mean, just because the law changed doesn't mean what he did at the time was not illegal. So, and this, excuse me, and then the city council created this new set of, this new ordinance for vacation home rentals, and they specifically included these conditions that if somebody had a past infraction, they couldn't apply. They weren't eligible to apply. They, on purpose or not, they did not include the 2-year exemption or the 2-year horizon. They said it's a ban. You know, that's a decision our city council made, not for us to deliberate. So I'm looking at this just very, like in a very straightforward sense that he knew he was violating the law, and then came back looking for an appeal, came back looking for a permit, and that's not allowed under the current law. So it's like, it just doesn't seem allowed to me, and I think it's really important that we need to be, that we're consistent with staff, who I think does a great job. Their deliverables, their interpretations, their demeanor, their customer service, like I've just seen nothing but great work from staff. So I'm likely to just to follow the staff's recommendation based on the evidence that they collect and present to us. But back to that kind of question I have to Commissioner Williams, like regardless of what happened to Measure T, it didn't change the fact that what he did was illegal and he has an infraction on the record. Is that correct? From like a legal standpoint?
It's the commission's job to make the assessment of the facts here to determine if a violation occurred. You've heard testimony and evidence from staff regarding this matter. I would just advise you to make your decision based on what was presented by staff.
Okay, thank you. That concludes my question and how I'm feeling right now.
Did you have a question?
Well, just because it's something's illegal, a law is illegal. Once that law has been found unconstitutional, somebody had a traffic accident and a traffic ticket, and then they went to court and appealed it all the way up to the Supreme Court, to whatever appeal up, and then it was found unconstitutional. That would mean that it would invalidate that citation. So if a law has been found constitutional, it's unconstitutional from its inception.
I think we're going to go to Mr. Anhoff and come back the other way. I know you had a statement, so feel free.
First of all, this is not so simple for me. Had Measure T passed the smell test, it would be very simple right now. But the thing is, it didn't. It's unconstitutional, and whether or not that I go against the grain on this thing, I'm just going to have to do that, Mr. Grove was a very good permit holder without any problems. He paid all of his fines. I think if there's any compassion in the world, that he should be showing some. When I started to go ahead and kind of sum this thing up or put down my thoughts, I put down, I had three different scenarios, analogies, you might say. If I received 3 speeding tickets in a 3-year period of time, and I paid my fines, would the DMV revoke my license? Probably not. Revocations are for very serious offenses. And what we're about to do is punitive to these gentlemen right here. Myself, I have an extensive insurance background, and in all contracts you will find liberalization clauses. Simply stated, when the rules, regulations, and laws change for the benefit of the contract holders, said benefit is immediately extended to the contract holder. Last but not least, if I was convicted of a marijuana charge with a long prison sentence, only to have the same state legalize marijuana should I serve out my sentence. For some of these reasons, I think it is absolutely punitive if this gentleman is denied short-term rental in the future. Thank you very much.
Struggling with this one. Gavin, I think you made a really good point that this is the first one of many that we're looking at. And being consistent is important, but I also think that we're going to have to look at these individually. And I realize it's not part of the ordinance and not the way that we're supposed to look at it, but the fact that there were no renter violations, no neighbor complaints, no garbage, parking, parties, this is all just an online advertisement. We don't even have any actual evidence that he rented it during those time periods. And on top of that, this being a forever decision, that they can never rent their family cabin out again to help cover property taxes and insurance, and I am having a hard time with it. And I hadn't thought much about Measure T and, like the reverse impact, but you made a really good point, Doug, that it is unconstitutional as was deemed in court. And so how do we look at everything in reverse with that? So, yeah, it's a tough one.
Thanks, everyone, for your thoughts on the matter. I had a quick question for staff. If, regardless of what the outcome today is, should Mr. Grove decide to appeal the decision again, does he have that opportunity, and does it at that point go to city council or something else?
I'll defer to Mr. Barzell on that one.
So this is the final appeal with the city. It does not go to city council. You're the final decision maker for the city. I wouldn't want to advise the appellant on his rights beyond that, but this is the final city appeal.
Thank you for that.
I think that was just made into the last ordinance, was it not?
The recent ordinance the city council passed made the decision that this is the final appeal for the city for these.
Thank you.
I'll just
Gavin,
say
go
last
for
thought is just I really do want to reiterate that I think it's really important that we follow council direction. Like, we're not making the rules, we're not making the laws. It's our job to make sure that they're complied with. And this is definitely precedent making, setting, and I don't feel it's appropriate to set the precedent that people that don't follow the rules can show up and hope to tug enough heartstrings based on their individual story to get special treatment. So.
Yeah, I think, obviously we're all struggling with this because it is depending on how you view this, whether it's in the larger context of sort of what's happening with Measure T as an idea and as a regulation in general, and what was deemed about it in court, more recently, versus what is the appropriate, consequence of violating the rules while they were the rules. Especially, since our appellant has, agreed that he was aware of the rules that were in place at the time of these violations. And, regardless of whether it was an omission or not, it is definitely a struggle because, as Mr. Feiger said, this is going to absolutely set the standard for all appeals we have moving forward. I do find it surprising that there is no grace period for a citation. That came as a bit of a shock to me, that these could be issued day in, day out, once Measure T was passed. I was a little surprised about that. And though I understand it's not the city's, mandate or really responsibility to inform the owners via any other means besides certified mail, I wonder whether that is best practice, in the future. But yeah, I think those are sort of the two things that we're up against. However, I think that Measure T being deemed unconstitutional is beyond the purview of the Planning Commission. Though I agree with Mr. Williams, a statement that this is something that does have an effect on how we should be approaching these citations in retrospect. I think it is kind of beyond what we are being asked to do today specifically. I think that is something that would probably need to be resolved in a different forum. And so that's kind of where I'm at, though I agree that, Measure T being found unconstitutional has bearing on this. I don't think it's our place to take that into account, since it is not part of any of the evidence that is before us.
I guess my question then, based on that, would be then how can we make an appropriate decision when we don't have that information with Measure T? And if it was unconstitutional, and if looking back that actually wasn't, it was illegal at the time, but looking back it's not illegal now. So yeah.
If I may, so actually, if you look at the commission protocols in subsection C, so it does state, if issues are raised during the hearing that cannot be immediately responded to by staff, the hearing should be continued to have such information available for the appeal process. So if we find this to be pertinent, I would suggest that we continue the hearing, and we will try to look into this issue and bring it back with further information.
So I think that this case and all future ones are important enough that it warrants that continuation. I think that is something we should really resolve.
If that's the case, like what, we should put together maybe, like what's the specific question? Or do we have a few specific questions if we're going to continue this and we all understand that this is setting precedent?
I'd like to take a shot at the question.
Okay.
So the question is Measure T being found unconstitutional in general something that we should take into consideration when reviewing appeals for violations at the time when Measure T was in effect? And to continue on to that, do we have any sort of limit on that? Like, are we looking at violations that are bureaucratic in nature, such as what Mr. Grove is dealing with these citations for listings? Or are we also looking at any kind of violation, including noise, trash, illegal parking, etc.? Because I think that there is a big difference between those kinds of violations.
Clarification on that, though, there is evidence that he rented it out. We just don't have it in front of us. So just clarification on that one. And then potential scenario that might help answer this question is, in my mind, if, whatever happens in the legal process, Measure T is finally officially overturned, are those citations that people got then, are those gone, do those go away? Because if not, that makes it seem like they still stand and there's still evidence. If they go away, they no longer become evidence, right? Mm-hmm. I guess that's kind of my question for next time.
I would suggest we include that in the request for information here.
Okay.
I would absolutely agree. Do we have any additional questions that we want to add on to this continuation? No, I think that that'll probably satisfy.
Actually, can I ask one more? I don't know exactly how we get the answer to this, but is there a way to ask City Council if they purposely want it to be a permanent ban, or if the 2-year ban ban that was in the previous ordinance was just not carried forward? Like, was that was that intentional? Because I know it all happened pretty fast. Yeah, it is a big difference. And if it was on purpose, great, follow the rules. If it was unintentional, maybe that's an opportunity for city council to.
We can certainly look into any record we have of the intent of council.
Also, was it the intent of the city council to have the 3 strikes over one weekend? You know, you're in violation this day, they write, second day they write another violation, the third day they write a violation over a 3-day weekend, and then automatically get an automatic ban for them.
Sure, I can respond to that. The ordinance is written in a manner that that citations are given to an event. So over a weekend, you can get multiple citations based on the complaint.
So over a weekend, an event could be, okay, I've got somebody in my place, I'm advertising. So one day you can get 2 citations.
In that situation, and maybe I can ask Ms. Wheeler to explain, I think that would be considered one event. So it's possible that over a weekend, you can get a citation on Saturday and then another citation on Sunday, because those are 2 separate events.
So yes, your answer was, I can get a citation for renting on Friday, and I get a citation for renting on Saturday.
You can get a citation for renting on Saturday and then a citation again for renting on Sunday.
Right.
If a citation is, if you get 2 citations on a Saturday, generally that's treated as one event.
I guess to me that is, you know, and obviously we are not addressing this, but that is concerning because there is theoretically a time period between when the citation is, you know, given, but then the certified mail is sent. So you could potentially, let's say, get cited on a Sunday, get the letter on a Tuesday, and get another citation on Monday while you don't even realize you're supposed to address the first one. I mean, I know theoretically you're already aware that you're in violation and you shouldn't be renting to begin with, but technically speaking, you could be, you know, acquiring additional citations before you've even been notified that you have a citation.
Theoretically, that is correct. I believe that the case that Mr. Grove was trying to make is he believes
In
that's
addition
what
to
happened
that,
him.
all the people who have these short-term rentals, they're out-of-towners. They're all over the place. So, you know, it's very important to at least allow them the opportunity or whatever to know that they got the citation and not give them several citations in a very short period of time. So I don't know if that needs to be cleared up or whatever, brought to city council or how that is to be handled, but in my views, that a person could actually have a void permit in a matter of a week with 3 citations. Is that correct?
Theoretically, yes.
I would suggest at this point that you propose a motion
Yes.
to continue the hearing with further direction to pursue these additional inquiries that you want staff to look into.
All right.
And I suggest just be specific with an itemized list of the questions. So if we could, because we're talking about, we have a lot of information that's being requested. I want to make sure that we capture everything that staff wants. So if we could just go back to those items and see if we can put together a list, I think that would be helpful.
Okay. Okay, we'll try. I think you are taking better notes than me, so if there's anything, please jump in. I will go ahead and make a motion to continue this item in order for staff to gather pertinent information so that we, as the Planning Commission, can make an informed decision on this item. So the first is regarding whether Measure T being found unconstitutional has bearing on our decision-making. Second, whether there is, should we consider some sort of limit on how we consider the violations in terms of whether they are an administrative matter where it is a citation issued for an illegal listing versus violations that are more you know, more consequential, like noise or trash or parking. Yeah, or anything of that nature. Third, can we check with city council as to whether the decision to make the ban based on those 3 violations permanent, very intentional, or was that something that was just omitted since the previous ordinance did give a time limit? And was there another one?
Violations one after one day.
I don't know that that is something that, do you feel like you need an answer to that in order to make a decision on these types of appeals? Because
Well, it should be limited to make a decision in this appeal.
Right, so I personally don't know that I need that information, but what do you think?
Well, I think it's.
I guess my question would be, would that even be a question for council? Like, I'm not sure, I guess, where that comes from.
For the questions about council's intent for some of these, I suspect there might not be much information we could provide besides the bare text of the law. We can certainly look into anything that you find pertinent, but I certainly can't guarantee that we'll find much beyond just what's written in there for those.
I appreciate that. I guess let's go ahead and add the question then also, whether there was any consideration given to citations being issued for every event, and with the consequence being that you could potentially receive notice of the citation while more violations are basically piling up. That is my motion.
Actually, I'd suggest we add a date certain to when we'll actually hear this. So
Okay.
does other staff have a recommendation for when this should come back?
I would recommend that we could likely bring it back at the next scheduled planning commission meeting. Addressing most of these questions, probably with the exception of the intent of council. I think that we would have to confer kind of offline, but the process of agendizing that and how we would go about doing that, we'd need to discuss that matter with city management. But I think the other questions are more kind of research questions that we can address by the next meeting.
Well, I don't know that we would be asking it in an open session of city council or anything like that. I suspect that
And that's
the
fine,
information
'cause-
would be on the record from previous meetings where the ordinance was deliberated on. I suspect that will be the extent of it, so I don't think we'll have to put this on an agenda for city council or anything like that.
Also, this permanent ban kind of bothers me about, that 3 violations and it's a permanent situation. How'd that come up? I mean, who decided that?
That was adopted as
At a city council
ordinance.
meeting, it was
Yeah.
adopted that 3 and you're done for good, for life.
That was adopted
Okay.
by the council in the ordinance.
Because that's concerning, especially in cases like this right here where you've got somebody in front of you here that is very sincere, so on and so forth, that it is an important area to discuss.
So, other staff, are you okay with the next planning commission meeting being where we schedule this for?
We are.
We are.
Okay, so I would recommend that.
Mr. Feiger, did you have a question?
Yeah, well, that motion is still on the table. Just want to amend it, but the one piece that was missing, I jotted down, was asking what happens to citations people got during Measure T if Measure T is fully overturned, like when that actually happens. Do those citations still stand? Will they still be evidence in these appeals, or do they go away because Measure T was found unconstitutional? So that's the other question. Because I think that'll affect every one of these appeals, because those citations are the evidence in all these appeals, right? So.
Measure T has been overturned. It's under appeal right now, but
It's still
it is the
appeal.
law of the land right now.
So yeah, is it okay if we just tack that onto the motion instead of repeating the whole thing?
Yes.
Okay, thank you.
Okay, I'll second that motion.
Okay, we have a motion and a second, and now we can vote. Okay, the motion to continue this item to the next planning commission meeting carries.
I just, before we move on, I did want to say, so Mr. Grove, just so we're clear, we will continue discussing your case at the next meeting, which is on September 18th. So we hope you can join us. If not, please join us via Zoom.
Well, actually, if we could just give him the date and time.
Oh, it's at 3 p.m. on September 18th, which will be Thursday, a Thursday.
And it'll be held in city council
Yes,
chambers.
it will be held here at the city council offices. So 3 o'clock, Thursday, September 18th. So put it on your calendar, and we hope to see you then. You are done, and we are going to have a little bit of a rejigging of our schedule. We are going to hold off on item 3 and move straight on to item 5, which is an 11-unit residential project and major design review and special use permit. And we will first hear from Ms. Goodman.
Good afternoon, Madam Chair and Commissioners. For the record, my name is Gretchen Skolman, and I'm an assistant planner with the city. The item before the commission is an 11-unit residential project located at 1050 Fremont Avenue. The applicant, Exline & Company, representing Esoteric Holding LP, submitted an application for a major design review and special use permit for a multifamily use at 1050 Fremont Avenue in February of 2025. The project is not covered under the city's MOU with the Tahoe Regional Planning Agency, and a separate TRPA review is required. This application has already been submitted to TRPA. The project site is currently developed with a single-story commercial building known as Nell's Tahoe Hardware. The project site is in close proximity to restaurants, transit, a grocery store, and public services such as the library and the Future Recreation Center. The site is classified as Bailey 7 and has TRPA verified coverage as well as CFA and has not been deemed historically significant. The site is located within the Town Center Land Use Designation of the City of South Lake Tahoe General Plan. This area provides a mixture of uses, including high-density residential. The site is also within District 1 of the Bijou Al Tahoe Community Plan. District 1 allows multifamily dwellings with the approval of a special use permit. The allowed density is 15 units per an acre. As you can see, part of the project site is also located within Plan Area Statement Bijou Pines Special Area 1, shown in yellow. To meet the desired density of 11 units, the applicant is proposing to deed restrict APN 027-170-012 and APN 027-381-001 as one project area. APN ending in 012 is the larger unit, and APN ending in 001 is the smaller unit that is located in the residentially zoned area. This application is only for the multifamily development that will take place on the larger parcel. If the applicant wishes to develop the smaller parcel, a separate submittal is required. A deed restriction for density purposes has been conditioned in the city permit under condition number 14. Moving on to the site design, there will be 11 units. There will be 5 duplexes and 1 standalone unit. All of the structures will be served by one main driveway with individual driveways accessing the units. Each unit will also be served by an individual bear box. Under attachment 3, it shows that South Tahoe Refuse has agreed to service these bear boxes, and the typical multifamily residential dumpster requirements have been waived. The applicant is also proposing a 2-step condominium subdivision. A tentative map review will be required to subdivide the 11 units into condominiums. Once this application is submitted, this will be presented at Planning Commission and City Council for approval at that time. The conversion of the development rights from the existing commercial floor area will be reviewed and approved separately from TRPA. The landscaping plan has various plant species that are approved by TRPA, as well as parking barrier details. The applicant is proposing trees along the street frontage, as well as a 5-foot wide sidewalk, which is in compliance with the Al Tahoe Bijou Community Plan landscape guidelines. The snow storage locations are labeled on sheet A-1.2 of attachment 2. Here you can see the front elevation of the duplex building design. There are various windows, there are 2 balconies, and the design showcases some natural materials such as layered stone, wainscot, and cedar trim and fascia. The use of the natural materials is encouraged in Chapter 6 of the City Code for multifamily developments. Here's a side elevation showing those 2 elevated balconies. And again, that cedar trim throughout. And then here is a rear elevation. There will be a small patio accessed by sliding doors on the first level. Here is the front and rear elevation of the single unit building. Again, very similar. There'll be 2 balconies as well as a first level rear patio. And here is a side elevation. It should be noted that each unit will be 4 bedrooms and 3.5 bathrooms. Other amenities include in-unit washer dryer, walk-in closet, and 2-car garage. You can reference attachment 2 for more details of the proposed floor plans. The materials for the building consist of a majority of metal roofing and siding. Some colors include dark green, gray, and brown. There is proposed wood siding that will be stained redwood. Some of the other proposed colors include 2 different tones of copper-toned finishes. Other materials include that stone, as well as wood decking with metal rails. Overall, the proposed 11-unit residential development is consistent with applicable city plans through increasing housing opportunity by furthering diverse housing options close to public transit and services. The project site is desirable for a multifamily development as it is adjacent to various commercial and recreational work opportunities, as well as public service uses. The site will be adequately served by utilities and services through a new fire hydrant and expanding existing utilities. The project site is located within the boundary of the future Midtown Area Plan, which is proposed to allow multifamily dwellings by right pending approval. The addition of a usable sidewalk and landscaping will help increase connectivity and aid in drainage for the area. The financial implication for this project is potential property tax revenue. For these reasons, staff is in support of this item. The item before the commission is a motion to pass a resolution finding the project is categorically exempt from CEQA, approving the major design review and special use permit based on the consistencies made in the staff report. I'm available to answer any questions as well as the applicant. Thank you.
Thank you so much. I don't have any questions on the presentation. Does anybody on? Nope.
Just
Go for
one.
it.
Did the not allowing the 2-step conversions, did that go through in the area plans, but it's just that this is outside the area plan, that this is outside the area plans, that this is still possible, or did that not make it into the area plans after the amendments?
That was, that did not make it an area plan, and this particular property is not currently an area plan. It's part of the Midtown area plan, though.
Cool, thank you.
All right, I think that's all. I'm assuming we're going to hear from the applicant. Welcome, Mr. Exline.
Absolutely pleasure to be with you, Planning Commissioners. Nick Exine on behalf of the property owner. I'm going to make this as brief as possible because South Lake Tahoe decided to change their football game to Dayton at 4:30, and to the depth of my soul, I want to be there. So really, I just want to highlight this. This is a great project. It's an infill project. That's going to vastly improve the property taxes, the curb appeal, the sidewalk, and providing housing at this size and square footage is in alignment, as stated by Gretchen, in terms of Tahoe's housing plans. It's walkable, it's sustainable, it's a great location. We all know this area. And so I'm here to just, answer any questions through the process. Andrea Gonzalez in my office, who led this effort, deserves all the credit. And so thank you so much for your time today, and please let me know if you have any questions.
First, I'm going to say, Mr. Imhoff, I think you got to go.
I do.
So,
Thank you very much.
do you have any questions before you head out?
No, it seems to be a great project. They're all 4 bedrooms?
Yes.
They're all 4 bedrooms. And do you have any idea what the price point might be?
That's still being determined. Obviously,
Determined?
price points based
Yeah,
on
we're
square footage.
really-
And I'm doing a home remodel myself, and so it's a process. And so we don't have all that.
20-some parking spaces, right?
2 per unit.
Okay.
So
Yeah, 'cause-
yeah, so 22.
Sounds adequate because of, they bring a lot of stuff here that doesn't have adequate parking, but apparently you think that you will have on that.
Yeah, absolutely.
Okay. Thank you.
No, and thank you so much.
Thank you, Mr. Imhoff, and good luck. We still have quorum, and Mr. Exline, unfortunately, we're going to keep you here a minute longer. Does anybody else have questions? Mr. Williams?
So you don't have an idea of what the construction cost is going to be at this point?
I mean, you're looking.
Even a guesstimation?
Yeah, I would probably put you at like somewhere between $700 to $900 a square foot. I'm seeing remodel prices, just in context, for just internal remodels, getting somewhere between $550 a square foot now.
Okay, and so each unit is how many square feet?
Sorry, what's that?
Each unit is how many square feet?
1,700 approximately.
Okay, so way over $1 million.
You know, unfortunately, that's just where we are now. As you look at, I guess what I could tell you is we're paying less per square foot than say like Sugar Pine, and working on affordable housing efforts in various different parts around the lake. Per square foot, we'll pay less than those as well, simply because of the way you can able to do it on the private market versus kind of, the public space. But as it relates to kind of price per square foot for housing, like I said, it's the cheapest you're going to get because of the way we're able to negotiate price in comparison with a public entity.
Because this is a special use permit, this normally isn't like designed for this area necessarily. Are these actually going for sale, or are they going to be like multifamily rentals or like short-term rentals? What are these actually planned for? Just trying to figure out like if this is a really good like special use for this area.
Yeah, no, I think I want to step back from this area. I know this area well, knocking on doors for the SCTBD board. Just past the single-family lot is a series of multifamily units. So I would argue to the special use finding that's made, and this is going through the TRPA process as well, that this is in complete alignment with the character of the area. So I would tell you, to Mr. Hitchcock, as this go through with the Tahoe area plan, or excuse me, the Midtown area plan, had we been able to wait for that point, this would not be a special use. And so, kind of the question, it's just a moment in time. And so I think it fits as a result of just the surrounding character. Again, there's several multifamily projects that would be to the south of this, just the next street over. And then again, you want to site multifamily and higher densities in areas that are walkable and accessible to everyday uses. Safeway's right there, shopping, the beach, so on and so forth, transit. And so I would tell you this is probably the ideal place to put multifamily in the Tahoe Basin.
Yeah, I can expand on that. The Bijou Tahoe Community Plan, we don't have a copy here, but I believe it was adopted in 1995. And so it's old. And, back in those old days, when we were doing those community plans, we were really kind of focused on the commercial aspect of it. And housing was a secondary part of that whole planning process. And that's probably why it was deemed to be a special use. I can tell you that moving forward with the Midtown Area Plan, we're making housing will be allowed by right in this Midtown Area Plan. And I agree with Nick, the special use findings can be made.
We'll take one issue with that. The 90s is not old. I know, now down there, 44, jeez.
Quick question, or clarification, actually. So they're going to be sold as condos, so each individual unit would be used in various ways. Could be a long-term rental, could be single-family home that lives there year-round, could be potentially short-term, right? It's just depending on the person who buys it and what they choose to.
Absolutely, and
Yeah.
I'm sure, over time, I think you're going to see probably a mix of that, as places are bought and sold, as we're all familiar kind of with the Tahoe real estate market. But, going back to Mr. Williams, as new builds exist today, again, in comparison with other things, non-subsidized, we'll be able to, compete per price per square foot. And unfortunately, the Tahoe Basin, the price per square foot is just incredibly high right now. Unfortunately, not looking to go down anytime soon.
Chair? Yeah, I'd just like to expand on the issue of short-term rentals. It's kind of nuanced for this property. The standalone unit can probably get a short-term rental permit, but the attached units cannot. The way that the vacation home rental ordinance is written, attached condos that have shared common walls is defined as a multifamily dwelling unit, and the code prohibits short-term rentals in multifamily units.
But wouldn't that apply? This is in the town center, is it not? It's zoned town center?
Well, it's not, it is a town.
It's commercially zoned?
I think, well, I'm not sure about the town center designation, but it's not in the tourist core. So condominiums that qualify for short-term rentals are allowed in the tourist core. Condominiums outside of the tourist core, in order to qualify for a short-term rental, they have to be detached units, standalone.
Okay.
It's kind of like the ones that you see on Emerald Bay Road.
Bay Road? Okay.
But if they're attached,
But then again, the city council can be changing that on the condos.
yeah, it's up to the city council when they do get a report back, I guess in the future here, they may or may not, it'll be up to them.
Yeah, the report back to council will be on September 9th.
I have a clarifying question for that, and I don't know if this would be like a loophole, but because obviously the attached units here have like a firewall, which is gonna go all the way up, if the applicant chose to, for instance, build 2 walls with like a 6-inch gap in between, would that now be considered not sharing a wall, even if they share a roof?
No, because the ordinance also uses the term roof.
Perfect, thank you for clarifying that.
That's not being considered.
All right. Do you guys have any other questions? If not, I have a list. All right, Mr. Exline, when are you planning to demo Nell's Hardware?
I think, it kind of depends on the approval process timeline. I think, as we all know, the construction and grading season going from October 15th to May 1st, just where we are here, this action is going to be heard before the TRPA hearings officer September 11th. And so I think there's, we're going to be advancing the demo approval to say it's going to happen this year. It kind of depends on a lot of what the contractor is going to say and how far they could go, meets when we're able to acknowledge. So I could see a reality in which it's demo, the site's stabilized, and then, really kicks off kind of May 1st next year. Just so they get the head start kind of going into the new year would be, again, it could go a bit further, but if, watching a lot of projects through many years, I could see that kind of reality playing itself out.
Do you anticipate any remediation for like hazardous materials or anything like that? Have you guys done any testing already, kind of getting ahead of it?
Yeah, we're kind of in that space now. Just to Andrew Gonzalez, that's here, had just kind of been authorized to start moving forward, kind of getting everything primed for demo. With a lot of different things, it's kind of capacity, and people, like all things, tend to want to start moving with those things once it becomes seemingly more real. And now that we're in front of this approval body and then TRPA, a couple weeks from now or a few weeks from now, now we're kind of moving forward with all steps.
So in an ideal world, would the owner want to start construction as soon as next summer? Or are they being realistic and thinking more like 2027?
No, you'd start next summer.
Okay.
Yeah, I mean, if you get an approval by TRPA in September, I usually don't get to submit to TRPA in September to start in May 1st. So that's more time than you're ever going to get. And so really it just gives the time. But obviously, the problem with contractors in the basin is, they've been working kind of on efforts. And so unless you have somebody lined up to get a project like this, of this scale going, it usually takes some time. And so that's why I would see demo to real project advancement going into 2026.
Are you anticipating any sort of shared common areas, public areas, or anything like that as part of this project?
Well, via the 2-step subdivision process, post-subdivision, obviously that has to be approved by this body and the council. All the units will become, standalone APNs, and the remainder of the parcel will become common area under a single APN, governed by CC&Rs, subject to every member in the entity. So, fundamentally the same as kind of every type of development like that.
So they're not really planned as part of this current project, but may develop later on through some sort of HOA or collaborative process?
Exactly, right. And I think, the appetite for some things like this and on a parcel this small. And then there's some kind of question in terms of places with, access to the beach like this, what kind of amenities people want. And so, it's a fairly straightforward site plan now, so nothing dramatic plan now, but obviously would leave that open in the future and then get the appropriate regulatory approvals as needed.
Same thing for bike storage.
What about bike storage?
Will it be proposed as part of your final plan? Is that something that you guys are thinking about?
I would say in terms of bike storage, people generally store their bikes in a garage. I would never, just as a side for bike people, don't lock your bikes up outside if you have a garage, especially now, especially if you got an EV bike. And so, we would provide bike storage in alignment with city code. I would say in uses like this, generally people are going to be utilizing their own kind of garage spaces and so forth for storage.
Sure, you can interject.
Yeah, just on that one real quick. The parking spaces, the 22 are in the garages. There aren't any parking spaces, so people are not gonna, if they park their cars in their garage, won't have space for their bikes too, right? So, but
granted,
and then technically, because it's not an area plan, there's no bike requirement.
Yeah, that's right. There's no specific bike requirement in the citywide design standards.
All I will tell you, sitting right now, I'm happy to take anybody on a tour. My wife is actually listening to this because she wants to know when we're headed to the game. I have a single car garage in Tahoe, and I probably have 14 bikes in there. So you're all welcome to come by and see, but I think you can make it work.
But where do you park the car then?
Well, there's fairness to that. That's usually the driveway, Gavin. But again, my wife is listening. Now we're in a sensitive subject matter.
All right, next. So I know these will eventually become condos, which is great. And I appreciate very much that you have a single ensuite bedroom downstairs. I imagine that is to accommodate people with mobility issues. Do you expect to create or ramp up any of the proposed walkways into the buildings as well to accommodate those issues, or is there always going to be a step?
I think it really, like most kind of single-family residences, kind of the inclusion of that ramp, isn't too problematic down the road. You don't even actually have to pour anything. Mm-hmm. And so it really kind of be dependent on the individual to use. Generally speaking, people would prefer the option of having a step. And then, if somebody needs that, because you're exactly correct, the purpose for the downstairs bedroom was exactly that. And so, you would be able to add a ramp, if desired, but it's just not proposed right now because, again, generally speaking, people would prefer the step and then give people the option for the ramp if they would prefer it.
Okay. I would just urge you to consider it. Looking at your elevations, I found it interesting that 7-foot plate heights are proposed. And I don't have a dimension on here. What is your proposed floor framing system? Because I understand you have a very limited maximum allowable height, so that is probably what presupposed the limited plate heights. But that is very short for today's standards.
Right.
And even to achieve that, it looks like you have less than a foot for the floor framing. So how are you doing it?
I wouldn't, want to give you that answer, kind of in the context of this, kind of meeting. It's kind of more of a building department related question. And so fundamentally, we were navigating the planning and approval process given the regulatory codes before us. And as this go to building department, this will also have to be approved by the building department. And so whereas I don't have that information exactly today, and I apologize, everything, the city will have bites at the apple to ensure kind of compliance with all kind of international and specific city codes as it relates to building and, the connectivity pieces.
Was it at any point a consideration to reduce the number of bedrooms and either have 2 stories with taller plates and maybe some dormers to achieve an additional living area upstairs? Or was it always the intent to maximize with 3 stories?
So this, we provided all options in terms of optionality as you described, and this was the desire via the property owner in terms of, kind of their extensive experience in terms of their decision making. And so, in my role, that's what we went forward with. And so, to design kind of characteristics, internally, really to the purview of the property owner and the developer, and then also the individual that wants to buy it, right? To your question, I think the market will dictate how this all works. And so to the person's, gamble, if they will, to this development, but they feel, very comfortable.
And then just to kind of piggyback on that, and this is more just because of your expertise with planning, do you know if this area has the potential to achieve bonus height through density or anything like that?
Not current. I don't believe so. I don't know, John, if you have a different kind of take on that, but I don't believe so. And I was just looking at the kind of the ordinances that exist. I think it's an interesting question in terms of, I actually don't have a great answer. I don't know.
Yeah, it's subject to the TRPA height chapter. I haven't had a chance to, we are proposing changes in height in the Midtown. I don't know if this is one of the locations, but there's potential that we may allow more height.
I would definitely urge you to keep an eye on that, and especially when you go to hearings officer, I think that would have a major impact on what you are proposing in your design. I mean, I understand today we're just looking at the special use permit in general as an idea, but I do think that just looking at these plans, I would urge you to keep it in mind.
Absolutely. No, but I promise you we have it all lined out. That I can assure you.
Awesome. Those are all the questions I had. Do we have anything else? Go for it, Ms. Williams.
Couple of questions. So there, if I understand this correct, there's the one lot and then there's a second lot.
Yes.
How come you didn't just merge the two lots together?
They're currently in different zoning jurisdictions, and so one's in a community plan area, one's in a plan area statement. We've raised this as a comment, in the Midtown area plan. There's a couple clients we're actually working with that have bisected zoning, and really just kind of legacy items. And so, again, given kind of the design ethic of wanting to have kind of a single-family residence and the multifamily and separate parcels for this design, it wasn't, terribly impactful. But it was something, that we had talked about with Mr. Hitchcock and kind of throughout this process, and Gretchen as well. And so, but really in terms of, again, because of what the property owner wanted, kind of the bisected zoning, worked for us.
Okay, so the second lot is going to be deed restricted so that nothing can be built on that second lot?
No, so what it means through a project area deed restriction as it relates to coverage, it means you sum the two parcels coverage allowances together. And so what would typically happen if you move coverage from one lot to another lot, you'd have to submit an application with TRPA to do so. When you establish a project area deed restriction, the example I always give is ski resorts. The reason you do that is if Heavenly wants to move something from here to here that happens to be on different lots, you don't want to have to submit an application every single time to do that, right? Although it's subject to, kind of standard code review and approval. And so all this does is it merges the lots essentially for the purposes of TRPA entitlement. And, just as a fact, like I use deed restrictions very, very frequently. And, honestly, every kind of project of any substance you see exists on some level of deed restriction like that.
Okay, so that second lot can be developed if they bought it coverage from someplace else.
Yeah, I mean, so really what it matters is, and I can't remember the specific volume, so I do apologize, but, you have the two sums. Really what's happening is some of that coverage from the single-family lot is moving over to the multifamily lot because it's all Class 7 land. And then really what's happening is that the single-family lot is simply left with less coverage, right? Because it all equates to the same. And so, in essence, what it means is taking coverage from the single family means you're developing a smaller single family residence fundamentally, right? And using the coverage elsewhere. Similar to any kind of coverage distribution you look for, whether it's just a single family residential project or multifamily.
Okay.
Yeah, Chair. So TRPA allows contiguous parcels to aggregate their coverage and put it in the project area. But to do that, you have to record a project deed restriction for the project area.
Okay.
So basically, it's a way for the developers to move coverage around without having to merge the parcels.
Okay, so the second lot, all that coverage is being used onto the first lot?
Well, they're going to be transferring the coverage from that lot to the larger lot, and then if the Midtown area plan is successful and move forward, we are proposing to add that little small notch into the Midtown area plan. Then potentially if the coverage standards, then they can have more coverage at some point in the future.
Okay.
But basically, it's just a way to aggregate coverage without having to merge a parcel, because not everyone wants to merge parcels. So.
Okay. And the second thing is, through the years I've been on the Planning Commission, we've approved quite a number of projects where the someone got it approved, okay, and then they immediately sold it. A perfect example would be the one at next to IHOP. And then there's another piece of lot that we approved a project on Emerald Bay Road, right behind the Bevmo. I'm hoping that these people actually have their financing up in line and they are really willing to develop this project instead of just try and flip it off into something else. You know, another one would be where the Wells Fargo Bank on the Nevada side was, where they got a project approved and then they're trying to sell for something else. So hopefully these people actually do intend to develop it instead of doing a flip.
Absolutely. And I'm hopeful as well, although I got to say, when I sign up as a consultant, I never look at people's bank accounts. I just take them at their word, but I share your hope moving forward.
Thank you, Mr. Exline. I don't think we have any additional questions for you. Hang out for just a second. I think we will go ahead and open us up to public comments. All right. Oh, come on up, sir. Yeah, go for it. Welcome.
One, I don't believe there's any three-story units in that area. And have you looked at the view shed and potentially blocking view shed from the buildings that are behind you? So that's one question. The other is the coverage, and is there any plan for runoff sediment collection? And then the third one was low-income housing. It appears that most of the units that are behind you or to the south, I guess, are rental units, low income potentially. Are any of these going to be considered for that? That's all I have. Thank you.
Thank you. Mr. Exline.
Absolutely. So, first tackling height, actually as Mr. Hitchcock mentioned earlier, for an area like this, it's actually really restricted in terms of height in comparison to other town centers. And even in several months, when the Midtown Area Plan is eventually adopted, height will actually be increased. So in the future, this is actually going to be shorter than will be allowed. And so what I would say in the TRPA code, as it relates to height, has been done so to kind of via the environmental approval processes, investigating things like, views, shadows, all these various different things. And so us just being in alignment with the height is, really the considerations we had given. And then in terms of looking at, kind of affordable housing, obviously the city, each jurisdiction around the lake has tackled this problem differently. We interact with all jurisdictions. The city is, predicating their affordable housing, if you will, quote unquote, based on size and square footage. And so, based on the sizes, we're in alignment with those goals. I mean, the great unfortunate thing is just, again, the price per square foot to build, but we're all kind of locked into that. We'd all get away from it if we could. And so it was really designed in kind of coordination like that. There's something I feel like I'm missing. So there was height. What was the other one?
Water runoff.
Oh, water runoff. Actually, I'm glad that was brought up, of course. So as you might, everyone that's probably been by Nels, and I'm assuming everybody has, it's a pretty big, expansive area, parking lot, old, not great for BMPs, a lot of compacted dirt. So actually, from a water quality standpoint, having a new build completely engineered for, water collection, treatment, and percolation is significantly better than kind of the existing condition. As we're all kind of familiar with older, Tahoe sites.
Thank you.
Thank you.
Do we have any other additional public comment? Seeing none, Zoom.
We'll go ahead and open up our Zoom platform for anyone who would like to provide public comment on agenda item number 5. And there are no hands raised, Chair.
All right, we will close public comment, bring you back to the Planning Commission, and we'll just kind of do what we did previously. Mr. Williams, did you want to start us off?
I have no issues.
Every time these come up, I wish it was more affordable and not just going to be expensive and short-term rentals, but it's housing. So. Yeah.
No questions. Thanks.
Yeah, I think in general, it's, the sentiment is basically the same as was brought up in public comment. And to Mr. Exline's point, the construction cost really prohibits affordability unless there is a lot of, public sector involvement, whether that's through grants or other financial resources. I suppose the one thing, in terms of how we're seeing development moving in that area, more housing is more housing. That area does make sense for dense development, and I like the selection of the colors. I'm sure there's going to be a thorough scenic analysis coming into play, so I wish you the best of luck. And does anybody have a motion? Yeah, go for it.
Make a motion. I'll make a motion to pass a resolution finding the project is categorically exempt from CEQA pursuant to section 15332, class 32 infill developments. Number 2, granting a special use permit pursuant to City Code section 6.55.620. Number 3, approving the major design review number 25-029. And number 4, making all other findings set forth in the resolution.
I'll second it.
That motion carries, and I will note for the record that Commissioner Imhoff is absent.
Thank you, and I would like to propose a brief recess for 5 minutes. We'll come back at 5 p.m. All right, I think everyone is here. So we are going to jump right into our next item, which is our pre-approved accessory dwelling unit design discussion. And there is a motion on this. This is not just a presentation. And so we will hear from Ms. Plotner. Welcome.
Thank you. Good afternoon, Chair and Commissioners. My name is Crystal Plotner, Assistant Housing Planner for the City of South Lake Tahoe. Today, staff will present on the new pre-approved accessory dwelling unit design project. To address housing costs and lack of affordability, the state and city have passed new laws and ordinances to encourage the construction of accessory dwelling units, hereon referred to as ADUs. ADUs are a crucial element in the city's plan to provide a diverse housing supply. Pre-approved ADU designs provide code-compliant ADU construction plans that can be obtained quickly by a property owner. It would not have to go through the plan check process, which reduces both costs and development timeframes. On March 12, 2024, the City Council directed staff to develop a request for proposal, or an RFP, to procure a consultant to develop pre-approved ADU plans that would be provided to the public for free in the city. After review of all submitted proposals, the design firm Workbench was selected. On December 10th, 2024, City Council approved a professional services agreement with Workbench. The plan check-ready construction plans will include 4 design types that were selected by City Council: a studio ADU, a 1-bedroom ADU, a 2-bedroom ADU, and a garage design with an upstairs ADU. At the June 3rd City Council meeting, staff presented the completed parcel analysis of developable city lots to better understand development constraints such as average home size, vacant lots, coverage, and setbacks that would determine the size of an ADU. The analysis showed that approximately 38% of developed lots in the city have less than 800 square feet of coverage available for an ADU, and the majority of vacant parcels could also only accommodate an ADU of 800 square feet or less. City Council directed staff to continue working with Workbench on the pre-approved ADU designs and modular products with a focus on designs that are 800 square feet or smaller. With this direction, Workbench provided a total of 9 initial designs, and joining us on Zoom is Workbench architect Libby Barnes to present and discuss the proposed ADU designs. Libby will be joining us on Zoom, and I will click through the presentation for her. Libby, are you there? Oh,
yes,
there
I
we
am.
go.
Hello. Hello, my name is Libby Barnes of Workbench. I am the lead architect and project manager for the South Lake Tahoe pre-designed ADU program. I'm really excited to be part of this program and to get to learn more about your beautiful city. Workbench has done many pre-designed ADU programs within the state, and we use that accumulated knowledge to help make for a successful program. I'm here today to share with you the project scope and the concept designs we've developed. The city has requested we design 4 different units, which comprises of a studio, a 1-bedroom, a 2-bedroom, and a garage with ADU above. As Crystal mentioned, in the spring we conducted a site analysis with the assistance of the planning department. We determined that due to the lot sizes and lot coverage restrictions, an 800 square foot footprint or less would be the best size for your city. Go to the next slide. Our project timeline, this is our basic timeline for the project. We understand there will be another city council meeting for final approval, and then once we get that green light, our next phase will be construction documents. Go to the next slide. So this is our project deliverable. The package will consist of a full set of architectural, structural, and mechanical drawings, as you see here on the screen. Okay, great. So we're going to show you our designs. But before we do that, this is just kind of outlining our pre-design process, again, looking at developable lots. And as you see, lots are small, so we're really, seeing the smaller size ADU as probably the most preferable for your program. Okay, great. So here on the slide, So what we're showing is just the basic footprints with the studio unit at 345, one bedroom at approximately 650, a two bedroom at 799. That is total lot coverage. It's not because we do include a front porch on most of these. And then the garage with ADU, that is the footprint. Okay, so we're here to talk about the studio. So here's our studio unit. It includes a full but compact kitchen, a living sleeping space, a bathroom, and a utility closet. Although small, the tall ceilings with large window areas will make the space feel much larger. All of our designs take snow into consideration, as well as the slope of the roof, and to have covered porch areas and outdoor storage that's accessed from the porch. Now, on this unit, we don't have an outdoor storage space. So as you can see, just go back.
Sorry, Libby.
Yeah, so as you can see, on the left is a floor plan. So the green area comprises of like the living area, the light blue is a bathroom, and then there's a small utility area. And just another thing to note, while we'll show the kitchen layout, we'll show the bathroom layout, the homeowners have the ability to select the finishes for the interior, the types of plumbing fixtures they want. And the only thing that we would specify is the mechanical equipment that will need to be, past the Title 24 Energy Code. Okay, next slide. The one bedroom plan. So this, that's fine. You can stay on the slide. So we provided several options for the one bedroom unit, but we felt that option A had the most efficient use of space. This unit has the potential for a sleeping loft, so we raised the roof at the back of the unit for more head clearance and roof articulation. As you can see from the plan, you enter, let's say from plan south, there's a large storage unit on the left-hand side, in which you could put a bike in there. And then you come in through the front door and there's an open living dining area. We have a set of stairs that will go to a loft. Like I said, it could be a storage or a sleeping loft. Underneath that loft is a kitchen, and then to the right is a utility area, which can house the washer dryer, hot water unit, and shelving. And then as you go to the right, we have another closet, like just a coat closet, and then a sizable bathroom, and then at the bottom right, a bedroom. Okay, next slide. This was another kind of roof option we were looking at, having it as a gable, but also having a slightly different floor plan, and we all agreed that option A was the best choice. Again, this was option C. Planning really felt that having a storage unit access from the outside would be challenging during those snow months when your snowpack gets pretty tall. Great. The two bedroom. This is the largest footprint of our designs. The unit offers plenty of storage. You can go to the next slide. So sorry, let me back up. So the unit is 745 square feet, but the total footprint, which includes the front porch, is 799. And so we've kept to under 800 square foot of lot coverage. This unit offers plenty of storage, including a storage loft over the bathroom area. The double shed roof allows for a row of windows at the clear story to bring in light. We did explore, go to the next slide. We did explore several other roof options for this unit, and we felt that the double shed was kind of most indicative of what you see in South Lake. And again, it offers that clear story light, which will bring plenty of light into the unit. And the final unit is a garage. The footprint, the garage area is 485 square feet with the unit area at 602, and the site coverage is 602. Okay, so you see here, this allows for a 2-car garage, which would be closed off from the ADU dweller. But and then, so the ADU dweller would enter from the side. They would go up a set of internal stairs and then come up into an open floor plan of, full-size kitchen, dining, and living area. The unit has a 1-bedroom closet with a bathroom and a washer dryer there that's in yellow. One of the things that you might notice on the site plan to the right is a red dashed line, and we indicated this on all the site plans. And so that indicates the potential for a firewall. So let's say a homeowner wants to build this and put it up against their existing house or close to another structure, they would have the opportunity to do so. So we would provide detail for a firewall. And we can look, we had provided a couple options, but again, this was a preferred option. This option had a set of outside stairs, but given, given your weather, we thought the interior stair would be the best choice. And here's another version where it's kind of half in and half out, but we really like the option A. And one other thing to note is that on option A, the homeowner has the opportunity as an alternate to have a deck. Yeah. Here we just explored some different design options. What we're going to do is because your code says the ADU must match the exterior style of the primary unit, they would do that in whatever color or finish that the unit is in, the primary unit is. And then for, like, say something like the garage or the accent areas, like at the entries of the other units, we would propose a wood or wood look for that area. And these are just ideas that we just throw up, like inspirational images.
Great, thank you, Libby. Staff reviewed the 9 designs presented and are recommending the 4 following designs. The studio, 1-bedroom option A, featuring a potential sleeping loft and exterior storage space that's located close next to the front entry. The 2-bedroom with the double shed or articulated roof line to allow for more passive light and solar energy. And garage plus upstairs ADU option A, featuring internal stairs and an optional deck. It is recommended that the Planning Commission pass a motion to 1, accept staff recommendations on the 4 selected ADU designs, and 2, approve the final pre-approved ADU plans with the recommendations incorporated by Planning Commission to be presented to City Council. Thank you, and we are available to answer any questions.
Thank you so much. Doug, do you have any questions?
Yes. So essentially, though it says site coverage is 602, it's actually going to take more than 600 square feet because you're going to have parking, on-site parking and things like that. How come they didn't think about doing a 2-bedroom above a garage? Maybe have a little bit bigger garage for that.
Libby, if you are still on Zoom, if you would like to answer that one.
I think we really wanted to minimize the footprint, given the 800 square foot restriction. So like, for instance, our 2-bedroom ADU is around, almost at, 800 square feet. So we just thought it could be utilized more if the footprint of the garage was smaller. And it was just enough to have like a standard 2-car garage with the stair to the side. But we did not consider a 2-bedroom above.
I think what I'm trying to say is, part of the footprint that we're required is on coverage, ground coverage. And parking is going to have to be considered when people are doing an ADU. And that'll take up some of the coverage. But if we had utilized on the 2-bedroom, put a garage underneath that, then that would lower the amount of coverage that would be needed for the property. So if we have a property that only has 800 square feet, they're not going to be able to do a 2-bedroom because there's not going to be any places for the parking to put in required parking. So that is my thought. And then my other thought is, why can't we just send all of these to give all these options to the people instead of just doing one of each?
So the professional service agreement, it only covers 4 designs, and it's in the workbench contract. So we could potentially bring all 9 to city council, but only 4, they will only develop 4 per the professional services agreement.
Yeah, so due to all the designs that are required and the time and work from Workbench, the cost would increase dramatically. And so with the contract that we have, that's why the 4 designs were incorporated.
So these are only conceptual designs?
That's correct.
And then the full plans are going to be based off the recommendation of us and the city council?
That's correct.
Okay.
Correct. Once city council approves the chosen 4, the recommended 4, then Workbench will build out the full construction documents.
Yeah, it's unfortunate that we don't have a 2-bedroom above a garage, because there's going to be a lot of lots that will not have the necessary coverage to include a garage or parking on their lots.
And John, you might have more insight to this.
Yeah,
Many of the detached or garage units that we're seeing built already have established driveways that would be calculated into the coverage, correct?
That's correct. And depending on where the ADU is constructed, if it's within half a mile of a transit stop, parking isn't required.
Okay.
In very few instances have we required parking for a lot of these ADUs. A lot of them are built with no additional parking.
Then on the option B for the garage and ADU, that one doesn't even have a shed coverage over the stairs. So that snow is going to drop right on the stairs, and you walk out of your house, you're going to have 5 foot of snow that you're going to have to shovel. It would have been nicer because option C does have a bit of a shed coverage.
Correct, and that's why staff are recommending option A because it has the internal stairs.
And just a comment, we're aware of that it didn't have the overhang, and we would have made that change had that been the preferred option.
And as a follow-up on the parking as well, within the parcel analysis that staff conducted and presented on June 3rd, within that analysis, there was a consideration that there was already an average of an existing 400 square feet of paved parking in the parcel analysis included when the average coverage per lot was calculated.
And then I would have preferred to have on option A, have that extra room that the stairs were taken up, and then having exterior stairs. Because the more because that interior stairs does waste a lot of space that could be used for bigger bedrooms or whatever. That's me personally. If I was going to be buying a house, I'd want more interior space.
We can forward that recommendation to the city council.
Thank you. Doug, did you have anything else? No. Gavin? No. Julia, do you have any questions?
I just have a comment.
Go for it.
Okay. My only comment is that I'm really excited the city is doing this. I think for people that, since ADUs are becoming more and more common, there's a lot of people up here that don't even know where to start. So I think this is a great project. And I also think that, just speaking a little bit on the other side of what Doug was talking about, ADUs are purposeful typically for like 1 or 2 people. So I think keeping them to these square footages, it is on somebody's property with a larger home, or they already have a 2-car garage and they're going to build over it. I think the design is ideal because it won't attract a lot of people living adjacent to somebody. And if there's a larger family or whatever, they're going to go look for a single family home. But I love the concept, and I think it's just a great that you guys are moving forward with this process. So thanks.
And I have quite a few questions. They're mostly for Libby. They're going to get a little bit more detailed, so if she's available.
Sure.
Maybe? Yeah, she's there. Okay. All right. Hi.
Hi.
So in terms of process, like as Julia mentioned, I absolutely appreciate the thought that has been put into all of these options. I think in general, they are very well considered. To kind of Doug's point about the 2-car garage, one thing I would consider, just because I have run into this issue on some of my own projects, is maybe looking at a tandem option for a few different reasons. One, limiting the amount of driveway that would be required for access to a single garage. Secondly, potentially adding a second bedroom, because now you could have a single run stair rather than a U-shape. And third, just because of the nature of properties in Tahoe, a lot of them are more of a rectangular thing. So having a square next to, a robust house, it might be more challenging to place on the parcel. So I think if somebody really wanted a 2-car garage, a tandem might be a good solution. Also, for the option A, that is the preferred option for the city, I am concerned that an 18.8-foot width for the garage is a little tight, especially with the double doors being proposed to the garage. I would suggest if that option proceeds, it should be a single garage door. And I know it's a little nitpicky, but just a thought. For the process of actually doing this, like let's say somebody comes and they select, a studio apartment, would they be able to work with Workbench to complete the site plans and the coverage analysis, provide any available modifications, work with the review and submittal agencies? Like, how does that process work? Or is this literally like, nope, here's your plans, these are the items that you get, good luck?
John, would you like to answer that?
I think the intent are, the plans are basically ready to go. And you basically, the plans you submit to the city, and it doesn't have to go through the plan check process. Now, if an applicant wanted to go back to Workbench and tweak those plan sets, I think that's well within their ability to do so.
I would add also, Chair, that so the professional services agreement with Workbench is just for the development of these plans. They're going to go through a plan check process. They're going to be pre-approved and then free to the public. But the city won't be at this point under this contract retaining the consultant on contract for like future alterations. So once the deliverable happens of these 4 plan sets, that would be the completion of this contract. So that could change in the future. Maybe there is some kind of we retain them on call or something like that. But under this contract, that's not what's proposed.
Right, so I do understand that. My question is, I guess, more in terms of like, okay, would a person just coming into this process being like, great, I just get a free set of plans, you know, I've saved time, I've saved money, this is awesome, but then realistically, just because of the nature of Tahoe, really they need that coverage analysis, really they need those site plans, those BMP calculations, they need approvals from the Liberty, from SDPUD, from everything. So that portion would really be on the homeowner.
That's correct.
Based on these plans.
Yes.
Got it. And in terms of modifications, then let's say that homeowner does want to make modifications to, let's say, some of the structural aspects or a minor design feature, and they don't want to work with Workbench. Is part of the services agreement a sign-off to share the electronic files for modification with an alternative designer?
I can comment on that. Just to comment on the first item that you mentioned, one of the pages that we'll include in the construction set is a site plan. So on the previous programs that we've done, the homeowner will have to show their property lines and basically where their existing house is, that square footage, and then they'll need to indicate where the ADU is going. So what often we would recommend is either they hire a local person or they do the site plan themselves, but we wouldn't do the site plan for them. As for your second point about modifications, that gets tricky because we have a licensed structural engineer that is a part of the package. And so you can't have basically two engineers on the same project, because I think there would be some concern from him. And even from us, if we could not share those CAD files with another designer and modify our design. So that homeowner would just have to use the plans that are provided or hire a designer, architect themselves and do a completely different design. What we try to do with these designs is make them as universal as possible. So we try to provide, we have our roof slope meets the minimum snow load slope, and we provide a lot of storage, and we give people a lot of opportunity to customize those ADUs on the outside and inside. But when it comes to the wall locations and roof beams and windows, that is set.
Appreciate that explanation. I think that's a really important point to clarify. In terms of, as you said, these are pre-designed and they are very specific to you as the architect and the engineer that's retained. However, California does have the code updates every 3 years generally. So are these going to be sort of like a living plan, which will include code updates as they occur?
I'll answer that actually. So right now, under the professional services agreement, it's just for this plan set. California state law did just change, so after the next item, the building code will be frozen until 2032. Local amendments will be frozen. And so during that time, these ADU plans will be available for longer than the previous cycles that were changing.
I feel like we just got a sneak peek.
Do you want to?
Forgive me, this is the first time I've used this microphone. Actually, building codes will not be frozen. What has happened is AB 130 was signed into law, and all that does is preclude any local amendments to the codes that will be adopted, and unless they're filed with the Building Standards Commission by September 30th of this year. We have no new local amendments to make the code more stringent, so the 2025 code will be adopted and go into effect. So as of January 1st, that's going to be 2026, so 2029, that would be the newest code cycle would go into effect, and the plans would have to be updated under, I don't know, another professional services agreement. How that looks going forward, that would leave that to the Housing Division.
Thank you for that information. In terms of sort of the design, and I know these are preliminary, but I would imagine that you have thought about some of this stuff. Are all of these units presupposed on a slab foundation, or are you thinking raised floor?
Yeah, that's a great question. We do that on slab. So if someone is on a slope, they would have to get a different foundation design, and we could work with them. I could find out from the structural engineer how he works with that, right? Because he has a certain specific anchoring and hold downs that are specific to the slab on grade. So we haven't, of the other ADU programs that we've done, we have not had a request for a change in the foundation.
Okay. And then as far as the mechanical systems, currently, are you thinking these will include some sort of a cooling AC system, or is it just heating? And are you considering gas systems or just going full electric?
Great question. We'll typically do a heat pump water heater, so which will provide both cooling and heating. And the city has requested that we provide mechanical plans for both electric and gas.
Awesome. Okay, very, very cool. And now kind of more specifically, looking at one of your 2-bed units, you had mentioned that I think it was the preferred option with the clerestory, which I totally agree. Awesome. So I'm assuming a rafter system. And how are you proposing to access the loft over the bathroom? I didn't see any stairs.
That would be a ladder. So
Okay.
on that one, it would have an opening above the bathroom, or next to the laundry room or the laundry closet, and yeah, it'd just be an opening in the wall, and they put a ladder up there.
Okay. And so, I mean, I know this is kind of going backwards, but if somebody wanted to go with a truss system instead, then they would probably just work with a different designer or something like that. I'm thinking of a cost-saving measure. Okay. And yeah. Okay. And then I think this one is more for staff. If the unit, if the homeowner wants to attach it to their existing home, would that make it a JADU or is it still an ADU?
Would be an attached ADU.
Okay.
JADU is a conversion of existing space
Right.
in a primary dwelling.
Got it. Awesome. And because Julia, you had just mentioned, if somebody wanted to add an ADU on top of their existing garage, but I don't think any of these units take that into consideration. I think these are all freestanding, but I wonder, because especially the units presupposing a 2-car garage, well, no, I guess then you'd end up just working with a different professional to actually accommodate an existing garage and then living area above, unless you did a demo and then redid it. Okay. That's all I had. Thank you, guys. I mean, honestly, this is a lot of work. And I agree that it's fantastic that the city is taking steps to provide these to the public. I think they will make a significant impact. So thank you.
I have one more
Oh,
thing.
you have one more question? Go for it.
So if somebody has a design change they want to do, is your company able to help them with any design changes, or do you just generally do big things like make ADU plans?
We would have to,
Outside the scope, where the person would be paying for your work.
yes, yeah.
So yes, they can do that?
They would have to contract with us directly, and it would be outside of the pre-approved ADU program.
Okay, so you guys do have the ability to do that then?
For sure.
Yeah, the caveat to that is that then it's not considered pre-approved, so it would go through the
That's
normal
right.
plan check process. But
Do we have have any other questions? No, I think that was really a thorough presentation, so I appreciate it. And we will go ahead and open this item up for public comment, which, well, let's just go straight to it.
We'll open up our Zoom platform for anyone who wants to provide public comment on agenda item number 3. And there are no hands raised, Chair.
We're going to close public comment and let's chit chat. Any thoughts, Doug?
No, I've got nothing.
Gavin?
No, I'll try to propose a motion. Anybody?
Yeah, go for it.
Great. I'll propose a motion to, number 1, accept staff recommendations on the 4 selected ADU designs, and 2, approve the final pre-approved ADU plans with the recommendations incorporated by Planning Commission, of which there were none. Do we have anything specific?
Kind of where, I guess we want to be specific.
That's a question.
So I know Doug really mentioned the garage, and I wanted to be very specific in that if it is within the parameters of the agreement, I would like to see an option for a tandem, because there's just benefits in my mind to a coverage calculation with that. And then also a revision to a single garage door versus a double on the preferred option. But that's it in terms of specifics.
Chair, can I ask a question? And it must be dumb, but what do you mean by tandem?
When you have a single garage door and the garage is longer, and therefore the 2 cars can park. Yeah, I've seen them usually, they're used a little bit more for storage, like people will use the back for, a workshop or whatever, and it's a single car.
Okay.
But it limits the amount of area you need for the driveway.
I'll second that. Oh, wait, maybe not.
I think,
We need to.
Dan, do we need to actually reword that, or does that make sense?
I mean, honestly, I think we can capture it. What this is a recommendation to city council.
Yeah.
So, I mean, I think we captured that.
Yeah.
The planning commission is recommending, approval of these. Yeah. However, would like to also propose perhaps looking into these other options.
Agreed.
None of which is designed yet today, so we would just be stating that. So I'm comfortable with that. We've captured it, unless Dan would like more legal.
I would suggest just restating it with the 2 additional changes that you're or recommendations that you'd like to include.
Yep, it's yours.
All right, I will make a motion to accept staff recommendations on the 4 selected ADU designs and approve the final pre-approved ADU plans with the following recommendations. Alternative garage floor plan, which considers a tandem access in order to reduce driveway coverage, and a revision to the garage ADU option A for a single garage door rather than a double garage door. And these are to be incorporated by planning commission to be presented to city council.
I'll second the motion.
That motion carries, and I will note for the record that Commissioner Imhoff is absent.
All right, last one, best one. Item 4, recommendation to City Council to adopt an ordinance amending City Code Title 6, Chapter 6.15, Section 6.15010, and 6.15.160 by adopting the 2025 California Building Standards Code, including the Green Building Code, Fire Code, related construction codes. We will hear from Mr. Harrison.
Good afternoon, Chair and Planning Commissioners. For the record, my name is Jeremy Harrison, and I'm the building official for the City of South Lake Tahoe. The agenda item that I'm bringing before you today is for the formal adoption of the 2025 Title 24 California Code of Regulations, more formally known as the Building Code. Included in this adoption are Appendix AW, which is 3D printed construction out of the California Residential Code, and the entire appendices of the California Fire Code, which covers items like building information signs, cryogenic fluids in medical facilities, all the way to temporary haunted houses. We've been requested by the City of Southlake Fire Department to adopt these. The Title 24 Code Library is published by the California Building Standards Commission on a triennial cycle, that is every 3 years. California Health and Safety Code dictates that the local jurisdiction adopt and enforce these standards and further allows more stringent local modifications based on geographic and climatic conditions. This agenda item is only for the adoption of the 2025 code standards and the noted appendices. No new local modifications are proposed on this adoption. About appendices, they are contained within the Code of Regulations typically and are not enforceable unless specifically adopted by the enforcing agency. Very often, unusual types of construction or conditions created by unusual events or activities are proposed without specific code coverage. In these instances, we are left referencing the code as adopted as it most closely applies to that particular item. Appendix AW for 3D printed construction for the residential code will provide greater opportunity for our community to look at other building materials, and the appendice will give us the ability to regulate that through UL standards. Additionally, the City of Southlake Tahoe Fire Department, as I mentioned, requests that we adopt all appendice items, and I gave you a couple examples of those. And they look forward to being able to use them going forward. This concludes my very brief presentation, and I'm happy to answer any questions that you may have, and I thank you for your time and consideration.
To make one clarification, so Mr. Harrison mentioned that the haunted house appendix was the last one. Actually, there's an additional one to the fire code, Appendix Q, Community Wildland Urban Interface Fire Hazard Evaluation Framework. That is the last one for those appendices.
For the record, I only noted a few of them. It goes from Appendix A all the way to Appendix Q, so there are a handful of useful appendices for our fire department to use. If you wish, I can go into greater depth and let you know what each one of those are. If not, that's fine as well.
I don't know that we want to be here that long.
I'm kind of curious, but it's getting late.
But go ahead. I mean,
I had one probably really quickly question. I just noticed in the red line that all the snow load had been pulled out. Is that, I should know, did it live somewhere else? I should know what happened. But.
So I'll talk a little bit about how our codes are adopted. We have several codes, such as the National Electric Code, IAPMO, which is International Association of Plumbing and Mechanical Officials. I probably got the acronym wrong, but a bunch of these type of technical resources, the American Wood Construction Manual, the American Concrete Institute's manual. The International Code Council adopts these codes and creates the model codes. So the codes will be adopted, they'll create their model codes, those will come out a year later, at which point California adopts those codes and we add our California amendments, publish them through the Building Standards Commission, and they become enforceable a year after the international codes. We have a very, very significant code change coming our way. One that precludes previous snow loading conditions. We are being directed to use the ASCE hazard mapping tool, which is an online mapping tool that tells us about our specific site conditions. For example, the property I reside at currently, I put it in as a risk category 2. At lake level, my snow load went up 97 pounds. And so that is what is going to happen. We're not leaning on a blanket snow load anymore. We are going to be leaning on what the hazard mapping tool tells us to apply for those specific site conditions. And that will include wind as well.
Great, cool, thank you. Actually, I had no idea at all. Yeah, fascinating, thanks.
So essentially, the state code requires us to approve it no matter what.
Yes, this is a formality.
Okay, I'm like, what's the purpose? Why don't they just say they approve it, we follow it?
I could not answer that question other than I get to see your lovely faces and you get to see mine.
So So kind of to piggyback on that, and this may be a little bit outside of the scope of this particular meeting, but I am a little curious, as you mentioned, there's a lot of change coming, and it's coming soon. Most of us in the design industry don't spend a ton of time, looking over code and reading all the new sections. Is the city planning on providing any sort of public information sessions on specific updates or amendments which are going to have a major impact on current practices?
We have been having some preliminary conversation just within the building division and community development services. We definitely would like to have some sort of workshops going forward. That said, we really want to get these codes in front of us. The orders for our libraries are in the works currently, and so we would like to sit down, extrapolate what new data we are finding in these codes. What I've seen already is almost like a complete reorganization, and it's not a very comfortable thing for us code professionals. So we definitely want to be able to palletize and understand this, and then reach out to the community and have some professional discourse and work on what any of the new stuff means and where all of the old stuff lives now, because it's all been reorganized. So yes, we're in the preliminary conversations about that, so you can look forward to us reaching out to the build community, whether you're a designer, whether you're a contractor. We want everybody on the same page, because in reality, we are all looking for the same focus at the end, a compliant project that someone can live in, work in, play in, whatever the use be, they can do it happily and safely, predominantly.
Thanks, Jeremy. And Chair, to expand on that, it's standard practice in the department to, anytime there's significant changes, whether it be code, operational procedures, software, things like that, to do outreach to the affected stakeholders. We do that on a regular basis with all our programs. So we will definitely be, as we look at this code, digest it, be conducting outreach and some informative training on that.
Very much appreciate it. I think that was my only question. Do we have anything else? Yeah. All right. Thank you, Mr. Harrison.
Thank you. I appreciate your time.
We're going to open it up for public comment on Zoom.
There are no attendees on Zoom at the moment.
So exciting. Awesome. All right. Closing public comment, back to the Planning Commission. I mean, it is what it is.
A lot of it's like increased energy efficiency, and I mean, that's kind of like a lot of the purpose behind the Title 24, right? So I know it's a burden sometimes, but it's for the long-term good, in my opinion. And we don't have a choice, so. With that, I will move to pass a resolution recommending the City Council adopt an ordinance amending City Code Title 6, Chapter 6.15, Buildings and Regulations, Section 6.15.010, and Section 6.15.160 by adopting the 2025 California Building Standards Code, California Code of Regulations, Title 24, including the Green Building Code, Fire Code, and related construction codes.
I'll second.
I can select it for you. Do you vote yes or no for the record? Okay. That
Yes,
motion
please.
carries 4 yeses, and I'll note for the record that Commissioner Imhoff is absent.
Guys, we're almost there. Updates and announcements from city staff. Do we have anything besides Planning Commission on September 18th?
Not for me.
None here. Thank you.
All right, and moving on to Planning Commissioner reports and comments. Anything exciting going on, guys?
Yes.
All right.
I would like to make a recommendation or a thought that Beach Retreat, which has given a 60-day notice to their employees that they're going to be closing down the end of October. And as we all know, sometimes the word is that they're probably going to be doing a $60 to $80 million work on that, which probably means they're going to be doing some scraping. If we can either talk with the city council, or if they want us to come back with an ordinance recommendation that no demolition permit may be applied for until it's passed TRPA, Planning Commission, and they have all permits, as well as a completion bond. I think we do not want to have a Biltmore or a Calneva or even the Tahoe on our hands again. And I think that we need to take a stance that this is something that we need to make sure doesn't happen at this very critical property.
Yeah, I appreciate that. We'll see what happens, but I do think that that is something to keep in mind moving forward. I think other than that, I hope everyone has a wonderful rest of the summer. Next time we'll see you, it'll be fall. So with that, we are adjourned.